Welcome to the Blue Heart Podcast. I'm your host and conversational guide, Lieutenant Joe Pangaro. This podcast is for you, the men and women of law enforcement, because ours is a noble profession, worthy of your heart, your passion, and your life. Now, let's get to the heart of the matter. Hey everybody, Lieutenant Joe here, Pangaro Training and the Blue Heart Podcast Network. So we're going to talk a little bit about today, for a couple minutes, is something that maybe we don't always consider until we have to be involved in it, and that is courtroom testimony. So you've gone out in the street, you've done a great job. Maybe you're a detective, patrol officer, you're an investigator in one of our prisons or our jails, and you've done a great job. And you've done everything you should have done. Maybe you did some search warrants, you arrested people, you've taken statements, you've done all of that stuff. And you put together an excellent report. Well, at some point, you're going to end up in court and you're going to have to testify. And we all say, oh, no big deal, right? Testify. We'll go to court and we'll tell our story. Well, it's not as easy as that. And the reality is many of us don't really understand the dynamics of the courtroom. It can be mysterious. It can be nerve-wracking. It can be something that causes problems. You can end up going in there and ruining a good case by the way you testify, how you testify. And that's what I'm going to talk about. So I have testified in local court, municipal court, federal court, state court, county court, my entire career. It is something that once I understood the dynamics of the courtroom and what everybody in that room, what role they play, what role I played as a witness, I found it to be a lot easier to do, and I became much more effective when I went into the courtroom. So that's some of the stuff we're going to talk about. All right, so let's think about this. I remember one time we had a pretty serious case. I was a detective at the time, and we were all outside in the hallway waiting to be called. We were sequestered. That's one of the first things you want to understand. What is sequestration? Sequestering means all the people who are going to testify, usually law enforcement people that are going to testify about a particular incident, are supposed to stay out of the courtroom. The reason they sequester you is because Patrolman Jones goes in and testifies, and then Patrolman Smith testifies. And if they're sitting in the room listening to each other, the theory is that Patrolman Jones or Patrolman Smith will adjust their testimony to match each other if they've heard what each other said. So the idea is the defense attorneys and the court and everybody else wants you to sit outside so you don't know what that other person testified to. So you come in, you testify based on your memory, your reports, your recollections, and then they can talk about the differences between what you said. But if everybody tells the truth, if everybody goes in and describes things exactly as they were, as you remember and as you wrote down in your report, there should be no problems, right? So this can be a nerve-wracking thing. So you're sequestered. My partner and I were sequestered with a bunch of other officers, and the first one to go in is a patrol officer who probably had 8 or 9 years experience. And he goes in, and it was a Superior Court case, so it was a serious case. And he was in there for, I don't know, for about 10 minutes. All he did was show up on the scene. He saw the accused, and he detained him until all the other officers arrived. So the prosecution was setting it up. How did we come across the defendant? So this young man came out. He was a pretty good cop, and he came out, and he looked really disheveled. He looked really upset. We said, what's going on? You all right? He goes, man, everybody should do that once in a while, meaning get into a courtroom under that kind of stress and testify. So we started to look at this, and we realized that when I started on this job centuries ago, it seems like, you got to cut your chops in court by going to municipal court. You know, you wrote a speeding ticket, you had a stop sign ticket, you had whatever, and you went in there, and the guy or girl you gave the ticket to gets an attorney, and they come to court, and they ask you questions. They cross-examine you. Then the judge asks you a question. The prosecutor asks you questions. And you learned how to testify, how to deal with attorneys, how to deal with judges and prosecutors through municipal court. A lot of places don't do that much anymore. How about your place? You know, now they make plea deals in advance. They change it. They cut it down to save on overtime. But that's actually a valuable training ground for an officer to learn how to deal with the court system, how to go in and testify properly. So when we talk about terms you need to understand the terms. I'll go over some things real quick. So I already talked about sequestering, very important. One of the other ones you're going to talk about is, well, obviously, you know, the prosecutor is the one who's prosecuting the case, usually law enforcement side. Then you have the defense attorney trying to defend somebody from some charge you leveled on them. Well, you have direct examination. Direct examination is when the prosecutor asks you questions. Well, normally when you're asked questions from the prosecution side, it's going to bring out all the good things about your case, what you did, how you came across the defendant, how you made the arrest, how you got your evidence, all of that stuff. It's all going to be positive towards what you did. Then you get cross-examination, and this is from the defense attorney, who's now going to go over everything you just talked about and try and poke holes in your story, find out where you made mistakes, to try and bring out the weakness in your case, right? And that's their job. That's their court-appointed job. Everyone is entitled to I'm trying to think of the term that they use, but a vigorous defense. Now, if you got in trouble, you'd want your attorney to make a vigorous defense. So I don't hold it against defense attorneys. You know, everybody makes jokes about defense attorneys. I don't make jokes about it. Some are good, some are bad, no doubt about it. But understanding why they're doing what they're doing and how you counteract it, how you participate in that courtroom, is going to make a difference in how your cases come out. So cross-examination is when they come out. Redirect means after they cross-examine you, now the prosecutor gets to go and maybe clarify some of the things that the defense attorney was asking about. So I don't want to call it a game. It's not a game. It's very, very serious what goes on in that courtroom. Someone, a defendant, has been charged with something. It could be with a traffic ticket. It could be with DWI. It could be with homicide. You know, they're charged with something. This is a very serious thing that's in our society, law and order, and you as an officer are part of it. So you want to make sure you do a good job, a fair job, a constitutional job, and then you testify as best as you can. So some of the things we're going to talk about, what happens and how are you going to feel? Now, I'm going to tell you, like I said, I've testified hundreds and hundreds and hundreds of times on very, very serious cases, and I got very good at it. I learned the process and I got good at it. I practiced it. I got good at it. But I'm nervous every time I go in that courtroom. And people will tell you, I'm not nervous. I don't care. First of all, in my opinion, I don't think they're giving it enough value as what they're doing. This is somebody's life on the line, one way or another, or their money or something. You take it seriously. Know your case inside and out, right? If you worked on a case with a bunch of other officers, you should know what everybody did. You should make sure that you read all the reports involved in the case, read the statements involved in the case, look at the evidence reports in the case, familiarize yourself going into that courtroom so you're ready to answer questions. All right, so what happens? You're sequestered and you're out in the hallway and you're waiting and you're talking with your fellow officers and this and that and the other thing. And all of a sudden the court officer comes to the door and says, Officer Jones. Oh, okay, here we go. Here's where it starts. So what's going to happen is that's usually a little bit, I don't want to say nerve-wracking, but it can be something that can put you off a little bit. Okay, here we go. Especially if it's a jury trial on a serious charge in Superior Court or federal court, you're going in, there's going to be the judge, the jury, the prosecutor, maybe it's the prosecutor team, the defense team, other people are in there. There could be cameras, there could be news media, people watching the trial. So you can be nervous going in, right? So one of the ways you counteract that, because how do you look when you're nervous, right? When you're nervous and you speak too quick or you speak too slow or you stumble or you're sweating or you're not looking professional, people look at that and go, what's up with this person? Why is she behaving like that? How come he's sweating like that? They automatically start to make judgments about you. And those judgments about you start the minute you walk into that courtroom. So here's some advice. When I'm standing out there and I'm getting ready to go in, your heart's probably beating faster. Your breathing is faster, right? This is what happens when you start to get nervous. Take a couple of deep breaths. Stand at the door. Usually the court officer is pretty good. They're law enforcement. And you say, give me 1 second. Take a deep breath in. Hold it for 3 seconds. Let it out. Do it again. Let it out. Seems silly, but I'll tell you what it does. It slows down your breathing, slows down your heart rate, slows down everything, calms you down so you can be more in command of yourself and your information when you go in there. It's perception in the courtroom. So that's why I don't want to say it's a game. It's not a game. but everybody in there has a role and they do different things. And sometimes it seems a little bit like acting. Like, you ever seen an attorney? Do you mean to say, isn't it true? And they ask all these things, right? Well, those are all real things that happen in a courtroom, and you're going to have to be prepared to respond to them. So once you take your deep breaths and you're calmed down, you're going to go on into the room. Now, got to remember, as soon as you step into that courtroom, everybody is looking at you. The judge, the jury, the prosecutors, defense attorney, everybody is looking at you. And they're already starting to make a determination of how they feel about you. Now, what do people say in the modern world? Or is everyone out there a fan of law enforcement? No. They think you're a liar, you're a cheater, you plant drugs, you hate people for all kinds of reasons. Any of us that are on a job know that that's not true. Are there some bad apples? Yeah. But the huge majority of us, we're there to do the right thing. Most of you probably in your interview to get the job said something like, I want to help people. And you really mean that. We go into a job of service to our community. We go in there to do the right thing. We go in there to help people and do what's right. So we should take it serious when we do that. So keep that in mind. So now, as I'm walking in the door, they're starting to judge me. Am I that cop? Now, who is that cop? Now, this is important for all of us in law enforcement to think about. How we interact with the public is hugely important. You start to put some time on the job and this and that, and there is absolutely out there the us versus them mentality. You know, it's all law enforcement, the blue line, and everyone's out to get us, right? And we can certainly fall into that. I hope you don't, but it does happen. It's natural because of the way people attack law enforcement. We're just trying to do the right thing, and they attack us. So they are judging you the minute you walk in. Are you that cop? The one that came over when they got stopped that time and talked nasty to them. The one when they asked directions, gave them a short answer. The one who gave their kid a ticket without asking any questions, right? Are you that cop, right? So as a profession, we need to remember we serve the public, right? Do our best to treat people the way you would want to be treated or you'd want your family treated. That's a good way to look at it. How you're dressed makes a difference. How you're dressed makes a difference when you walk into that courtroom. So what I try and tell people, whether you go in a suit and tie, you're going in a uniform, or you go in business attire for the women, whatever you're going to do, if it's in the morning you're going to testify, try not to eat a big breakfast, right? Oh, what's that got to do with it? Big breakfast. Now you get nervous, your stomach's growling, you might not feel right. And you're sitting on the stand and you're uncomfortable. You look uncomfortable. Somebody who looks uncomfortable looks like they're lying or not telling the truth. So you don't want that to happen. Besides that, if you're eating a lot of food and you get some stuff on your tie, you're in the courtroom, you know, in the lounge downstairs, and you have something to eat and you get it on you. Same thing for the afternoon. Light meal before you testify. Don't get stuff all over you. A clean pressed uniform, a clean pressed suit or business suit, whatever you're wearing. Limit the amount of jewelry you wear. You're not there to put on a show. You're there to testify. You're there to be looked at like a professional. So be a professional, look like a professional. Now you're going to walk up to the stand. And one of the first things that happens there is you got to go up and get sworn in. Now, this is also another time you can be very nervous. So you walk up and the judge is sitting there and he or she is sitting there and says, and the bailiff is there and says, place your hand on the Bible or whatever you're going to use. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? And I see a lot of officers do this. They stand like this. Yes, I do. Right? They look weak. They're nervous. They look nervous, right? You want to tell people what you want them to know. You are a professional law enforcement officer. You're there to tell the truth. You're not there to do anything else but relay the information of your investigation or your piece of the investigation, whatever it was. Put your hand on that Bible. Get it up nice and high. Let them see that this means something to you. The words of the oath mean something to you, that you abide by it. Do you swear to tell the truth, the whole truth, and nothing but the truth? Yes, I do. A nice, strong answer. Your hand up there, right? It's perception. It makes a difference, right? So then you sit down. Now, here's a couple of techniques that I've learned how to use. First of all, let me grab my friend here, the bottle of water. Okay. Now, it's very common when you're on direct examination by the prosecutor that are only asking you really good things and making you sound like the greatest cop and you did this good and you did that good and the perpetrator is all bad and all that. It seems very relaxing and calm and you feel good and you're answering really good stuff. But then you go to cross-examination and that defense attorney starts asking you stuff that's harder to explain. He starts to attack you. He starts to try and push your buttons to get you to be upset or whatever. because they want you to look like that cop, right? That's their job, to bring that out of you. So what I always do every single time I learned, I go up there and I stand there, you spell the truth. Yes, I do. And I'd sit down, Your Honor, can I have a glass of water? Almost always the judge has water on that counter for just that reason. People are talking, their throat gets dry, they get nervous, they want something to drink. And the judge will say, sure. You take it, you pour it into the glass, and then you drink a little water. Say, thank you, Your Honor. Now, the reason I do that is because I'm thinking long-term here about my testimony. I know that I can look different under direct with the prosecutor than I do with cross-examination. The key as a good witness is to look the same, because you're telling the truth, right? No matter what they do to you, no matter what the outside stimulus is to get you to react negatively, which is their goal, to impeach the witness, making you look bad, making you say something you didn't mean, is for you to understand that and to control it. So one way I control it, immediately, I'm controlling time, aren't I? Can I have a drink of water? Now I'm taking a drink of water. I put it down. Now I'm ready to testify. Later on, I might have another drink of water. When the prosecutor's asking me a question, I might stop and think for a second and say, get a glass of water, have a little bit of water. I'm stretching out my time, right? Because a lot of times defense wants to ask you questions, get you off balance. So you're thinking too quick and you say something you shouldn't, or something you say it the wrong way, whatever, that they can misinterpret or interpret for the jury in a different way. So I'm buying time by having that drink of water. And I do it when the prosecutor is asking me questions, when it's comfortable. So I set the baseline for everyone's expectation. So when the defense is asking me questions that are maybe more difficult, or I see that they're trying to push my buttons, they're trying to get me upset, excuse me, I need a drink of water. And I slow down the process. Not the prosecutor, not the defense attorney, nobody else in that room but me. I slow it down by having a drink of water, right? It doesn't seem like much, but it's important. It'd be important for you to give you a second to gather your thoughts. What is the question she's asking me? Why is he asking me like this? Take a deep breath and remain calm. Okay, so that's important, that drink of water. Now, when the prosecutor goes through your stuff, they say, Detective Pangaro, on June 5th, whatever date it was, 2015, were you on duty that day? Here's an important thing to do. Whether it's the prosecutor or the defense attorney asking you questions, when you answer, if you have a jury, you turn and you answer to the jury. You answer to the jury because they're the ones who have to figure out if you're telling the truth or not, right? So the prosecutor will ask you a question. Were you on duty that day? You turn and you look at the jury. Yes, I was. That particular day, I was in plain clothes. I was driving an unmarked car, and we were doing an open air drug market sting or whatever it was. Then you look back at the prosecutor. They ask you the next question. You look at the jury. You tell them the information. What you're going to see from lots of modern juries is they don't trust you. They don't believe you. They heard the stuff on the media. They don't like the cops because you lie, you cheat, you hate people for all kinds of reasons. You were probably bullied in school, and that's why you became a cop. All these things run through people's heads. We know it's not true, but this is what people are told about you and me. So we want to understand that that's what they think. You have to win them over, right? Eye contact is important, right? Look at them, answer the question, take your time, give them the information. What you might see a lot of is this. People are like this in the beginning. They don't trust you. They're listening to you. Oh, you're the cop. You're that cop. And as you win them over, if you see that they relax, you start to say, oh, maybe I'm making an impact. Maybe the jury's getting that I'm not that cop, that I'm just a person doing my job. You know, so we want to keep that in mind. Look at the jury. Defense attorneys don't like that. Defense attorneys don't like it. They will say to you, oh, excuse me, officer, I asked the question. I'm over here. That's what I call a softball. They've just thrown you a softball, right? Because now's your chance to tell them what you want them to know. And this is where, when we're in court, we don't always understand. We have a vital role. Our role is just as important as the prosecutor, the judge, the jury, and the defense attorney. And we have a right to participate in the events that are going on. So when that defense attorney says to me, excuse me, officer, look over here. I'm asking you the question. It's a softball. I say, yes, Mr. Smith, I appreciate that you asked me the question, but the jury has to evaluate my answer, and that's why I'm trying to give them the information. Now, what did I just do when I said that? I told that jury that they're important, that I respect them, that I know They have a role to play here. Now, defense attorneys don't like that. They want to control the room. So if they're smart, they will ignore it from then on. If they're not, they'll say, well, that's fine. I'd like you to look at me. And I just repeat, I appreciate that. And we're all in the same room here, but the jury has to hear my answer, and I want to make sure they understand it. You can go back and forth with this. At some point, the judge might say, officer, just answer the attorney. Okay. But then that's not you doing it. You were answering to them, right? And it's funny to say this, but it's true. In the world, people don't like law enforcement anymore. Who do people like less than law enforcement? Attorneys. So what are you doing? You're showing them that attorney is being that attorney, the one people don't like, right? You want to be approachable. You want to be honest. You want to be open. You want them to understand you're there to tell the truth, right? So this is an important technique. So I will do that over and over. Another thing that you're going to find depends on your name, right? I would ask everybody out there, is your name, your family name, and your heritage important to you? And I would say 99% of everybody says, yes, Lieutenant Joe, it's important to me. So my name is Pangaro. That's how you say it, Pangaro. It's really very simple. But I will have defense attorneys say, Detective Panano, Detective Pangino, Detective Pagaro, Detective Pagino, Detective Padat, and they say all these things. There's a purpose to that. They're not stupid people. They know very well my name. They heard the prosecutor introduce me. They heard all that. They heard me talk about myself, right? They're saying that so that you respond. Because what happens when somebody says your name wrong? What's a normal thing that people do just instinctively? They correct them. My name is Pangaro. Oh, I'm that cop. That's what I just told that jury. So I don't care what the defense attorney calls me. He can call me anything he wants. Over the course of time, and I worked with some great prosecutors, they kind of got what I was doing, that I was being a professional witness. I was good at this. As soon as they got to redirect, they would say, Detective Pangaro. That's how you say your name. Isn't that correct? Yes. Mrs. Jones, she called you Detective Pagano, Pagrino, Pagano. Why didn't you correct her? Softball number 2. I would look at the jury and I would say, the reality here is it doesn't matter what Mrs. Smith calls me, how she pronounces my name. It really means nothing in the scheme of things. What's important is that her client, Bob Smith, broke into Mary's house and stole her stuff. Now, a couple things I just told everybody with that. First of all, when you are law enforcement, you might be a person in real life, you're Mary Smith, John Jones, whoever you are. When you're there, you are law enforcement. You are the authority, right? And that finger of the law pointing at the defendant is very powerful, right? So when that person asks you, well, why didn't you? Because my name is not important. What is important is that Bill Jones, the defendant, broke into Mary's house and stole her stuff. Now, you want to see the defendant? You say, oh man, pointing at me. All that jury saw the hand of law pointing at that defendant. It starts to build your authority in the room, and you're being polite. And I look at the jury when I tell them that. It doesn't matter how you pronounce my name. What's important is what he did, right? So that's an important thing to keep in mind. That's another softball. I look for that. You might see lengthy questions by our attorney friends. Isn't it true that on June 5th, at this time you did this and that and the other thing here and there? And the reason that there's a big, long, drawn-out question like that is to confuse the material in your head. Confuse the material in your head. Too many parts of that question that you could get wrong or say the wrong thing or conflate something. And then they break it apart later. Well, the officer testified to this, and we find out it was this. So what you do is you very politely, you participate in the thing and say, I appreciate your question. Could you break that down for me? There's a lot of moving parts in there, right? And I tell the jury, there's a lot of moving parts in that question. Could you break it down? Now, I've had attorneys who are smart attorneys will say, yes, detective, I'll break it down for you. Let's start with the first part because they're smart. The ones that, I don't want to say not smart, the ones that are not as professional, that don't get the dynamic, they want to control that room because they watch TV too. And they see lawyers doing this and that, right? And they don't always have a lot of experience. They'll say, well, I want you to answer my question, this, that, and the other thing. And say, all right. I had one guy actually say to me, I'm sorry if you're not intelligent enough to answer my question, detective. Let me put it to you again. Now, was that insulting? It was. Bad mistake to insult me as a human being. Because if I'm too stupid to understand your question, the jury didn't understand it either. Right? So now you just insulted them. You see how you work this dynamic without being unprofessional, without making things up. You're telling the truth. Can you break that question down? So they do that. Now there's a lot more here, and I don't want to go on and on. This is a quick one. We'll come back and we'll do courtroom testimony part 2. But what I want to end with here for today is your reports and your case files and all the stuff that you want to bring up to the stand with you. All right? Anything you bring up to the stand, the defense attorney has the right to go and take from you and look at it. Now, I've seen people go up with their case file with everything in the case file. It's this thick, filled with reports and notes. And if there's something in there you doodled in the margins or something that, was part of just you doing, or you did it, you just doodled, you wrote something in there that you bought your lunch, it shouldn't be there, that a defense attorney, can I see those reports, please? And they'll sit there and go through the whole thing. Oh, officer, what exactly is this page? And what is that page? And right? What you want to do is, if you have a larger case and you have multiple reports, you have your initial investigation, maybe you have a supplement, maybe 2 supplements, a property report, a search warrant, anything that you have that you wrote a report about, you want to have a separate copy of it by itself on the prosecutor's table. So when they ask you a question, and that's why going through your reports and everyone's reports, you should know your case inside and out, right? But sometimes they ask some specific detail and you need to look at the report. Say, can I look at my report, please? My investigation report. Now, if you have them all in front of you, defense is going to have they're going to grab them all, look at them. If you ask just for your investigation report or your property report, they bring that property report up to you. The defense attorney is going to look at it and grab it. Let me see that. And then they'll hand it to you. It's for effect that they're looking at something. They're looking it over because you might be doing something underhanded, and they're going to check it out. They've seen all these reports. That's why you don't bring anything up there. You ask, you get the one report. Now you look at that one report and you deal with that, not everything you have. When it comes to that, we had property reports, as you probably do. And on bigger cases, there's lots of evidence, right? Lots of stuff out there. So one of the things I would do is I would ask for my report, and the prosecutor's asking me a question about the raid we went on and the property we took or whatever. And what I would do is I would look at the report for the same effect. I'm looking things over, making sure it's right, and say, is that your report? And I would look up at the jury and I would say, yes, this is my property report. In my police department, Happy Town Police Department, this is a property report. This is how we document evidence that we take from scenes or things we take from people. Over here's the date and the case number. Here is my name, and here's the date that I took the gun from Bill Smith, and I put it in evidence on this date. When I came to court today, I signed it out from the vault, the evidence vault, and I brought it to court. When I go back, I'll sign it back in. That keeps a track of where the evidence was, right? That keeps track of where all the evidence was, and that's what a property report is about. I sit down. So I did a couple of things. I'm educating the jury on police reports and what they are, but I'm also connecting to them. I'm telling them things. Nobody normally does a thing like that, but I'm telling them exactly what it is. I'm respecting them. I'm showing them they are part of this process, and it's important what they think, right? I've had jurors tell me afterwards that they really like that. I had judges tell me, boy, that's really a smart thing to do in there, the way you show the report and what it is. And I learned that over time. Right? I learned that over time, what was important. I watch how a jury reacted when I did that the first time. Then I did it another time. Then I did another. Then I do it all the time because it helps connect me to the jury so that I become an individual, trusted law enforcement officer. So they'll listen to what I have to say. I'm not that cop that they disregard or they think I'm doing something wrong. All right? Courtroom testimony is a very, very important thing. So you want to take some of these tips, keep them in your mind. We'll come back. We'll do another one because there's more things to understand about the courtroom. But you have a vital role in there. You are allowed to react to things, to ask questions, to say things to the judge, to say things to the prosecutor. If the judge doesn't like what you say, they'll tell you not to say it again. You learn how to work in the courtroom. You are a valuable member of that. And doing a good job is great. Presenting your case is really the end result of all your work, and you want to do it well. All right, so this is Lieutenant Joe for the Blue Heart Podcast telling you, hey, come back and see us again.
Lieutenant Joe and the Blue Heart Podcast Network would like to thank our sponsors. Blue 360 Media. You can find them at www.blue360media.com. And Medical Essential Diagnostics. You can find them at www.med-nj.com. We would also like to thank the Blue Heart Network production team, led by Senior Executive Director Todd Pangaro. Be careful out there. Do what's right.